Hi, everyone. Welcome back to another Friday. It's going to be the last time we do it on Friday. From now on, we're coming back to our Wednesday, 5:05. My name is Susan Ibitz. I'm a human behavior hacker. Some people hack computers. I hack humans, and I have fun doing it. Elba?
Hi, everyone. My name is Elba Uribe. I'm a human behavior hacker, too, and I am the CEO of Latin America.
We have one of those shows today. I'm going to ask you to bear with us. We have the top trial lawyer on the United States going piece by piece on the closing statement. We know that Johnny Depp already won, but how and why he won and how and why Amber lost. But most important, most people do not understand that in a trial, your lawyer, you as a client, the witnesses and the experts are on the eyes on the jury all the time. So when you don't use the right behavior, when you don't have the right prep, when your lawyers get to the after 7 weeks of trial tired and they don't do the closing right, can hurt you, but can hurt you too not to do the right opening. And Gessin is going to talk to us today. Again, please go below, take the time to go to his website and find out. His trials are so out of the scope that universities and another lawyers are studying what he does on trial to learn how to a trial need to be done. So we have a huge luxury. Thank you very much, Gessin, for being with us today, because I know it was the last moment, but this is a piece of art show. When we're not going to have advertisement, we're going to have Jesse talking all the time. This is a piece of art that how you get a closing statement, you break it down in little pieces, and we get the juice. And he says so many things that as a lay citizen, you can learn if you ever need to encourage any situation when you need to go a legal setting. Elba, what is your impression after recording with Jesse?
I learned a lot with him. And like I told him, I have a lot of questions. And when he started talking, I was like, that was my question. So the way that he explained things, I think it's a good thing because you can understand.
He was amazing. And by the way, I miss you to have you next to me. Elba went back to Guatemala. And I miss you, girl. We have a lot of fun in the two and a half weeks that we were together. So guys, again, it's a long show, but it's worth it. If you need to go in pieces, do it, but you don't miss this show. I think it's the best show we have done so far. So take a look. This is our show today. Jesse, I love to have a fighter as a lawyer to talk with, and you are one of them. You love to go to trial. You are specialized and go to fight for it.
I do. I love trials.
So I think we bring you in the right time. So it's one of the cases that we talked before that you were called like a week before one of the biggest settlement cases ever, and you're like, done. I win it.
Yeah, well, that's where I focus my practice is on taking cases that are on the eve of trial through trial, either with clients who have decided to move on from their current counsel, or oftentimes I partner up with lawyers who've been on the case for many years and present it to trial. Trials are its own legal specialty, in my opinion.
But your case was so good, so well put together, that it's a case analysis for other people to review how it needs to be done, correct?
Yeah, it is taught. That case from 2018 is taught in practice seminars on trust and estates and legal malpractice.
We're so lucky to have you. And by the way, you did an amazing work editing your own videos. You're a luxury to have as a lawyer. You went through the videos, you edited your own videos, you did the timeline. You must be a producer in another life. Thank you for that. So let's go to the timeline you put together so we can give a context about to people about this case.
Sounds great. And thanks for having me, Susan and Elba.
Thank you.
So this is the timeline you put it. Why and how this worked, Gessin?
Well, what you have is you have the beginning of essentially the defamation case. It starts long before the 2018 op-ed article in the Washington Post. It starts when Amber Heard files a restraining order while Johnny Depp is out of town. She runs down to court. She makes a big to-do about walking into court and getting the restraining order. And of course, the jury at least implicitly found that she had staged it by calling or by tipping off TMZ and other reporters. A restraining order that she got was what's called an ex parte application, which means that Johnny Depp did not respond and was not there and did not have his lawyers there. So it was just her statements without any rebuttal from Johnny Depp. They go through a divorce process, and in the end, what they get is a divorce settlement and a joint statement that reads, and I quote, "Neither party has made false accusations for financial gain. There was never any intent of physical or emotional harm." So at that point, Johnny Depp is essentially settled the issues pertaining to the restraining order, whether or not what she said was false in the restraining order. And for all intents and purposes, you'd think they'd move on. Not so. What happens is the tabloids in Britain do what they do and published a number of articles. And Johnny Depp decided to sue one of the tabloids for an article written in April of 2018, which refers to him as a wife beater. He eventually ends up losing that case, which was decided by a judge. And we'll talk a little bit more about that, the difference between a judge and a jury. But so he files suit in April of 2018 in England. Amber Heard then I can't recall if it was before the Sun the tabloid article in Britain or afterwards, but she creates a Washington Post.
If I'm not mistaken,
article.
it is in November 2018 that she published the ops after the Sun published it, using that article, like, okay, since the Sun published it, now I'm going to do my own op. And the institution she was representing, who apparently wrote the article, for what I understood, is that, since this happened on the media, we're going to use your name, your story, and your face as a domestic violence abuse survivor.
Correct. So then what happens is she writes the op-ed article, which according to her trial testimony was originally, the first draft was written by the ACLU, which is a civil liberties organization. And she of course adopts it, puts it under her name. And then Johnny Depp sues her for defamation in December of 2018 in Virginia, where the servers are located for the Washington Post. It was, of course, a print and an online article. So that's how it ended up in Virginia as opposed to California. Then Heard countersues Johnny Depp for statements made by Johnny Depp's lawyer about whether or not Amber Heard had created an entire what they called abuse hoax. And that's essentially the timeline of the case. And then, of course, it takes 4 years to get to trial, because that's the way our court systems work these days. Not like the movies where they're in trial the next week.
England was a judge and United States was the jurors. What is the difference?
Correct. So in some cases, even in the United States, are decided by judges as opposed to juries. In England, the case was decided, Johnny Depp's case against the tabloid was decided by a judge. So the judge made the credibility determinations as opposed to a jury. And the judge found that, I believe it's 12 instances of domestic violence more likely than not occurred. and that swung the verdict for the tabloid in England. Here, the jury was making the credibility determinations about the same incidents of domestic violence and came out the other way. And quite frankly, it was a higher standard of proof in the US, meaning that it would have been easier for Johnny Depp to win in England than it was for him to win in the United States. And there you go. So the verdict is quite shocking in that sense. But if you present cases enough to judges and juries, you realize that there's a big difference between a judge and a jury. A judge sees the evidence through the lens of the law and the evidence code and rules like hearsay and whatnot. Whereas the jury, they're humans, they're electricians and plumbers and professionals, doctors and whatever. And they're not trained in the law. So they don't have that gloss. And their unvarnished view of people, I think, was on display here. Whereas in London, that judge was certainly colored by the law. And I think that's why Johnny Depp was able to prevail here in front of a jury, even under a higher standard, because the jury wasn't looking at this as, is there some chance that there was abuse? It's just, who do you believe? who's telling the truth and who's not? It's that simple in front of a jury. In front of a judge, it's a lot more complex as far as which evidence shows what. And the jury doesn't look at it that way. They don't filter things that way.
You says that you were surprised about the verdict, and after that we're going to talk about the closing that you're going to be analyzing. But why you were surprised? You are a seasoned lawyer in this aspect. So when I say surprised, like, okay, why? Now I want to know why.
Well, I was surprised because I thought that the argument that Amber Heard's lawyers made throughout the case was there was one simple argument, which was, if there's any abuse, we win. And any abuse at all, verbal, financial, emotional, of course, physical and sexual, then we win. And if you watch the video of Johnny Depp banging the cabinets and yelling and pouring a goblet of wine, I think there's a lot of people out there that would look at that one video and say, done, it's over. That's abuse. We saw it ourselves. We don't need to see the text messages. We don't need to hear from Amber Heard's sister. We don't need any of that. We don't need to hear from her. We saw it with our own eyes. He was, according to his own language, the monster, and we've seen enough. That's why I was surprised. But the problem is that when you deal, and that would have been enough and it was enough for the judge in England. It's not enough for a jury, because a jury they punished Amber for lying, basically, is what happened. I think you watched the video.
I'm sorry, Gessin, for one thing is you lie, like, did you brush your teeth? Like, yes, can I smell it? You pass that, is innocent. But when you lie about pledging versus donating, when you become the face of something that you cannot prove, when you have bragging, when you bring the Me Too movement to the dungeon to rebuild again, I do think those are the things that people cannot forget. They're not a white lie. That is a malice lie. I'm going to use the legal term. If it's not go right there, let me know.
Yeah, well, so that's the standard under the First Amendment, actual malice. But we'll talk about that a little later. But yeah, they definitely punished her because they felt that she she didn't just lie about this, and it wasn't, like you said, it wasn't just white lies. She profited off this. She got a restraining order and publicized, clearly publicized it. She did the op-ed article for the Washington Post right at the time that her movie's coming out. She's not just, and then she lies about all that. She's profiteering off of this abuse. And that's really, I think, what aggravated the jury enough to disregard what is clear evidence of abuse. I mean, if you watch the video, if you read the text messages, Johnny Depp he's aggressive, and it is what it is. Now we all that's another problem, right? Is that I don't believe there was a definition of abuse in the jury instructions. So, abuse is a very subjective thing.
Well, Elaine mentioned that when she was doing the interviews this week, she says, abuse was misrepresented. And my question will be, I'm sorry, Elaine, you have 6 weeks and your team have 6 weeks to define abuse. And you have time in your closing, if you would be working with your team like the other team did, to says, okay, guys, before you go to the, during the closing, that's what we're going to talk now, and says, okay, before you go there, instead to go all over the place and trying to explain so many things, I'm going to explain only one thing. What is the definition of mental, emotional, and physical abuse? If the jurors will go out to deliberate with that fresh in their mind, because it was the last statement done to them, I think it would be different. Jesse, from the legal standpoint and your practice, what do you think?
Yeah, that was one of the big errors that their team made, was not honing in on a understanding of what abuse should be, especially after the Me Too movement, because I think it's shifted. That's number one. Number two is not having Amber Heard own up to quite frankly leaking the TMZ or timing the op-ed article or just
owning anything. She didn't own anything.
Lying. Yeah, I mean that was a huge error. You have to own up to that. Look, we all want to put forward a narrative of our clients as the hero, but heroes have flaws. They all do. I mean, we all know the hero's journey. It's a classic story arc. It's it's what Star Wars is based out of. We all know it. If you're going to use it to frame your hero, especially in front of a jury, they need to have flaws, and those flaws are usually as presented as part of the adversity process to become the hero. So they could have done it here. They had an opportunity to do it, but they made it was an error, and it cost them.
Superman have kryptonite, Spider-Man have emotions. Yeah. That's why we like them.
Yes,
exactly.
I think it's something that you can identify to, because they are heroes, yes, but it's like, okay, but you made mistakes too, you feel too. So I think that's a good point. So we're going to go to the analysis and closing statement, and then I love that how you chop it, and I want to I'm going to be this way. I'm going to mute my mic and wait for your analysis. But why don't you explain why is so important the opening and closing? From the behavioral standpoint, I will say that we have something called the hourglass. People is going to remember what you says because you frame the mindset. How am I going to start this career, this race? Because in the beginning, jurors are really pissed off because nobody want to be there. Thank God they didn't sequester them, because they're going to be really pissed off and going against the person who sequestered. And I'm going to leave that open to you, Jesse, to tell us. But it's how you frame, how am I going to start this project? It's the beginning. So they're going to start taking that. And the hourglass at the end is how you frame things that your client doesn't look good, things that can be questionable, things that are being raised on the media, because I do not believe, and after 10 days apart between the testimonies, they didn't check, or they were tainted, or the expert they bring from the media saying Johnny Depp innocent against Amber Heard, 3 things negative about her.
one good about him. So if they didn't know what happened in the media, they already know. So it's to frame things. So behavioral standpoint is a huge opportunity to use the hourglass system. Now, from the lawyer's standpoint, what is the closing and the opening and closing so important for a lawyer?
So, well, we start off with the philosophy of primacy recency, which is what you talked about. People tend to remember the first thing they're told, the last thing they're told. So that's, that's a tactic that we use throughout trial. We use it in openings, closings, crosses, directs, start strong, end strong. So, and then bury all the bad stuff in the middle. You have to own the bad stuff. So, openings are, I used to believe when I first started that closings were more important than openings, because what could a jury know when you first start? But I've shifted. I now think openings are actually more important than closings, but closings are still very, very important. The reason is that jurors start making up their mind as soon as they walk in the courtroom. So it's why prisoners aren't allowed to be in shackles or jumpsuits anymore. It's a constitutional violation for that reason, because they walk in and they see a juror, and they see a defendant in a jumpsuit, and they think, oh, this person's definitely guilty. It's bad enough that they're on trial, but that's why, because jurors start to make up their mind. So when you give a strong opening, you present a lot of evidence, the jurors are already deciding the case without even seeing the evidence come in. So I tend to believe that you can have jurors on your side, maybe not all of them, but you can get jurors on your side after opening and after the main cross. So I tend to believe that trials come down to what I call the 10 and 2. 10 exhibits and 2 witnesses. So here you got the video, you got the text messages, and then of course you got the 2 witnesses, right? Johnny Depp, Amber Heard. So that's the 10 and 2 in this case. But I find that no matter how complex a case is, jurors tend to hang on the 10 and 2. So openings, you get your 10, you introduce your 10 and 2, and then the jurors start making up their mind right there. Now closings, what I like about closings is that you've got jurors on either on one side of the fence or the other. Most jurors. Very few jurors by the time of closing are still on the fence. If they are, then it's a time to persuade them. But you're talking about maybe 1 or 2 jurors. You're definitely not talking about the majority. The majority have already decided one way or the other. Now, what you want to do with closings is you want to solidify their position. So when they go back in the jury room, they can advocate for you and bring up the points that you made in closing. So it's a time to remind them of their themes, right? So for example, Ben Chu said, "Me too," without the "me too," right? I'm sure there's jurors back there parroting that. The First Amendment argument on it by Amber Heard. I'm sure there's jurors back there parroting that. And we'll talk about what may or may not have happened in the jury room in a minute, but that's the point of closings, is solidification and theme reproduction that you introduce in your opening and throughout the course of the case, so that jurors can then be armed with that theme in order to convince other jurors to go one way or the other.
Wow. It's a lot. And we have so much to analyze. Elba, do we have any questions before we go to the videos?
No, I want to go to the videos.
Gessin, you want to talk about what maybe happened in the courtroom now, or you want to do it after we see the videos from the closing? Your call. It's your show. So.
In the jury room?
In the jury room.
Oh,
I want to know.
Look, okay, so here's what I think may have happened in the jury room. It's a weird one, right? Because Johnny Depp, so the philosophy is that they didn't believe Amber Heard on anything, and they believe Johnny Depp on everything. But that can't be totally true, because there's one instance of the jury finding for Amber Heard, and it was on that statement that she fixed the entire scene in the house when the cops came, and that first of all, that claim was by Johnny Depp's lawyer or that statement by Johnny Depp's lawyer was very fact specific. A publicist and a lawyer talked to Amber Heard, and she enlisted her friends to create this fake scene, spill wine and whatnot. So it was pretty factually specific, and it didn't really come out in the evidence. But at the same time, if they had found that Amber Heard had no abuse, then they probably would have found against her. So what I think happened was I think they may have horse traded, what we call horse trading in the jury room, which is there may have been a holdout, one or two holdouts for they had. First of all, this is also a weird thing in Virginia, which is that the jury has to be unanimous in civil cases. In California, that's not true.
It's a majority.
No, well, it's not a majority either. It's nine out of 4. So, or excuse me, 9 out of 12. So 3 jurors can go against it. So you can win a case with 9-3 in civil cases. In criminal cases, it's unanimous. In Virginia, even in civil, it has to be unanimous, but they had less jurors too. So, but here's the interesting thing. What may have happened is they may have said, okay, look, we'll give you 1 to the holdout juror, but you gotta come around on the other on all of Depp, and then we'll give 10 million to Depp and 2 million to Amber Heard. Well, what's interesting though is that they didn't fill out the form the first time around. So I thought she was going to get $1 until they came back with 10 million. I was surprised by that. But and then with the 5 million, which was a weird one too, Benjamin Chu, Depp's lawyer, only asked for 350,000 and they gave him 5 million on punitives, which was also kind of an interesting one because usually jurors don't give you more than you ask for on punitives, but there you go.
I always says you have 2 kind of cases. You can win a case because you have a great person, but the reality is how bad are the opponents is how good you're going to win your case. Until you don't hear the opposite side putting their foot in their mouth, you don't know how good the case you have. Gessin?
Yeah, I mean, that's true. You know, there's a lot of unforced errors in trial practice. No matter how much you prepare, things are going to come up. People are going to say things you don't expect. And that's just a part of being a trial lawyer. But certainly the ability to take advantage of an unforced error is critical. And in this case, the big unforced error, aside for the deep fundamental issues that we talked about earlier, the big unforced error was the Kate Moss opening the door to the Kate Moss testimony. That testimony clearly was not going to come in. And then Amber Heard mentioned it on the stand. And I think Ben Chu was literally fist bumping Camille. That's I think which also has its own problems. But in any case, that once they got the door open to that was a huge part of their narrative, which is that why is Amber Heard the only one? And that theme came up again and again in closing by Ben Chu, which is this is Me Too without the Me Too. So Kate Moss was a perfect bookend for that. And that was a huge unforced error by Amber
And to
Heard.
me was one of the best witnesses. Yes, no, I had a relationship. She was composed. She was so British. But the best part is she only answered what she was asked to. And she was so good, no cross-examination. I think it was like 3.5 minutes testimony, but it was so composed and so well done. Kudos. To me was the best witness.
Yeah, she was very powerful. And so were the police officers, quite frankly. Those independent witnesses were very strong. And that didn't have to happen. I mean, that was it was the flaw in prep, or it was just Amber Heard being Amber Heard, which was its own I'll call it a structural error.
I think it's the second one. Elba, do you have any more questions, or we can go to the videos?
No, now we can go. Now you answer what I want to know.
So from I would say 4 to 6 hours of closing, you chop a couple of videos. So this is the first one you selected. You want to explain why and do the explanation, or want to do everything after we show the video? Gessin, it's your call. You're the lawyer.
Yeah, let's play the video and then we can talk about it.
Okay, here we go.
On May 27th, 2016, Ms. Heard walked into a courthouse in Los Angeles, California, to get a no-notice ex parte restraining order against Mr. Depp. And in doing so, ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp. Today, on May 27th, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Ms. Heard said he is, and hold Ms. Heard accountable for her lies.
Gessin, all yours.
All right. So this is the very beginning of Camille Vasquez's opening. And I think that it's a powerful way to start in the sense that she focuses on the restraining order, which I think is the best part. That's really the strongest part of their case, is Amber Heard going in and choreographing this restraining order, and it's the first thing that she talks about. The first thing that she goes into is the restraining order, and then it's the ask, right? Not money, not not what you would normally ask for in a defamation case. It's, this is everything to Johnny Depp, and we're giving you, the jury, the power to give it back to him. And by empowering the jury right off the bat with something that they can't even give, quite frankly, I think is a very strong part of this part of the start of her case. And she, just as far as her presentation, slow, which is great. Some trial lawyers tend to move really quickly, to get excited. She's slow, she's composed. She's reading a little bit too much for me in what should have been.
That was my next question. What is your perspective about reading? And what I heard is, like, this case have so many intricate corners that missing it would erupt or disrupt the sensationalism that she was expecting to give with that.
At least the first paragraph should have been memorized, so that she's not looking down at a page at all. After that, fine. You want to make sure that you don't go off script, you don't make a mistake. I understand that. But the first big ask, I call it the big ask opening, or big ask start to her opening, should have been memorized. But otherwise it's very well done. It's very well delivered. It's very well constructed. And she's using the key fact in her favor, which is the restraining order, to tee up the empowerment of the jury, of giving Johnny Depp his life. And who on the street doesn't want to be responsible for giving Johnny Depp his life back? Like, wow, this is, I now have a lot of power. I'm special, right? And that's a very, very, very important part of trial advocacy, is empowering the jury to make the big call in your favor. And a lot of, I think, attorneys look down or talk down to the jury as if they don't know what they're doing. And in the meantime, they're not empowering them the way they should be. Right off the bat, Johnny Depp's team is empowering the jury. It's really important. It's very well done.
I don't want to even interrupt. Elba, do you have any questions?
No, me neither. I want to keep going because, wow.
Okay, we're going to go to the next video.
They knew exactly where she would pause, which side of her face to photograph. And the photos captured what she wanted them to see, the image of a battered woman. What the paparazzi did not know is that the dark mark on her face mysteriously appeared 6 days after last seeing Mr. Depp. It was a lie. She knew it, Mr. Depp knew it, and the multiple witnesses you heard from who saw her that week of May 21st, 2016, also knew it. But the world only saw what she wanted them to see. 2 years later.
Okay, lawyer.
All right. So what you're looking at now is you're looking at the introduction of sort of the cardinal sin of Amber Heard, right? It's the first lie. It's the beginning of a series of lies. It's the first time that Camille Vasquez says that Amber Heard's a liar, and it becomes the foundation of their case. The way that the visual effects is used is quite well done. Now, remember, these are two movie stars, so it's the presentation throughout the course of the closings are actually, and throughout the course of the case, are actually pretty low tech given the fact that you're dealing with two movie stars, right? You don't have any sort of recreations or any sort of things that you would expect or you actually see all the time in, say, a personal injury case. We don't have any of that. The way that she puts this slide together, it's well done. It shows the People magazine article with the supposed fake bruising. It has a article from the courthouse showing, all the people that were there. So it's kind of an introduction of this whole charade that Amber Heard created with the restraining order. The way that she presents it is well done. She's not just pausing because they're having a problem of the slide. She's pausing to allow the jury to think about what she just said. Now the slide comes up. They're going to read the slide, and she waits to talk about the slide, I think about 5 seconds, so that the jury is not reading and listening to her at the same time, which is a really important technique. A lot of lawyers just jump right to the slide without allowing the jurors to process it. It's very difficult for people to process two things at one time. And so what she's doing is she's allowing the jury to process it, and then the slide will be taken down as she talks and moves on to the next subject. And so it was a very clean presentation and a very well done introduction to what I call the cardinal sin of Amber Heard's lies.
I think that one of the things that Camille did really well, is the use of pause. People don't understand that when you're interrogating or deposing someone, if you make pause, the other person is going to feel the need to fulfill those pause. And sometimes that's when people talk more than they should. But if you know how to use it to make people think, it's really effective. So mastering pause as a lawyer, I think is an art that I don't see too often when I work with lawyers in trials.
That's very true. And I think what happens is lawyers tend to want to fill space in the courtroom, because that silence is, for many lawyers, it creates anxiety. Like, when nobody's talking, nobody's doing anything, the juror's just sitting there looking at you. But as you say, when you learn to use that space, it can be very effective. It can be very effective for making key points. And so I think she does that very well.
Elba?
Yes, I was thinking the same, because when I watched the video, I was like, why she's doing a pause? And then I started reading, and I said, like, yes, it's because she needs the jurors to pay attention to this and process, like you said, the information.
Okay, next video. We're having a party here.
They knew exactly where she would pause.
Okay, next one.
She wants you to believe that she was abused countless times. Countless times. Over the entire course of their relationship. But as Mr. Chu and I promised you, the evidence just does not bear that out. Ms. Heard has told you that she has mountains of evidence of abuse. But there are no medical records reflecting she sustained any injuries from the abuse she claims. Ms. Heard had medical professionals at her disposal. Dr. Kipper, Debbie Lloyd, her own nurse, Erin Filati. And yet, there's nothing. Ms. Heard took pictures all the time. Pictures of Mr. Depp sleeping. Pictures of cocaine. Pictures of property damage. Pictures of herself. And as an actress, she was photographed all the time. Where are the pictures of the horrific injuries Ms. Heard describes? Ms. Heard also took audio recordings and videos frequently. Where are the videos of Mr. Depp attacking her? Where are the audio recordings of Mr. Depp admitting to or apologizing for physical abuse? There are none. What Ms. Heard has, and what you've seen multiple times, is a video of Mr. Depp banging some cabinets around in a kitchen. A video that, based on the testimony you heard from Morgan Tremaine, the former TMZ employee, Ms. Heard seems to have sold to TMZ right before she was deposed in connection with her divorce from Mr. Depp. Sure, Ms. Heard can point to text messages where Mr. Depp is apologizing to her, but never for violence. Ms. Heard's counsel showed you Defendant's Exhibit 325, where Mr. Depp says sorry for, quote, my behavior. I'm a fucking savage. But this is not an apology for violence. It's an apology for the, quote, these heinous, slinging insults. Mr. Depp is apologizing for the words he used. Unlike Ms. Heard, who you heard apologizing for physical violence in multiple audio recordings, you have never heard that from Mr. Depp, because he never used physical violence against Ms. Heard.
Wow, counselor, it's a lot happening here.
Yeah, so that I know that clip was kind of long, but it was an important clip because what she does in what seems like a long time, it's actually a very short period of time, given that the closings ran hours. She's taking this, what we call taking the sting out of the bad facts. And she's embracing the bad facts, and she's doing it all in that one clip. So she just ran through the entire panoply of bad evidence against Johnny Depp and used it to her, or to the best she could, to her advantage, or to Johnny Depp's advantage. And so it's a classic trial technique. And here you're seeing a great example of how to use it. So she talks about the photographs of him. Oh, she says sleeping, but really we all know he's passed out, right? Yes. She doesn't put up the photo of the cocaine at breakfast, which is a delightful one, but
because you think she's minimizing, she's correcting the damage, controlling the damage with a minimizing anchor. If she says pass out, it's like punching, touching, destroying, kicking is different. So I think let's be clear. Behavioral wise, lawyers and people like us use minimizing words. So if you don't know what it is, we don't have time now. Google it or come one of our shows and going to explain that. But that was the truth. She minimized using the damage control that she needed to use.
Yeah, I probably would have used the word passed out because that's what he was. But look, she he never
denied that he had monsters, and he never denied that he get wasted. One of the things, he always owned his demon. She never did. And I think that is another thing against her. She is always somebody else responsible. Johnny Depp's like, yeah, it's happy hour someplace.
Mm-hmm. Exactly. I agree. And that's why I think Vasquez could have used the word passed out, but she used sleeping. But in any case, the overall point of that clip was to run through all the bad facts and turn them to her client's advantage, which was, look, this is the best they got, and it still doesn't show abuse, right? No, I'm giving everything that is against my client, and none of it proves their case, which was a very powerful way to do it. It's not always like that. You can't always take the bad facts in a case and use it to prove up your case. Sometimes the best you can do is neutralize it, but she's able to take it one step further. And you see it in this clip, how she compares and contrasts. This is what we have. This is what they have. This is what we have. This is what they have. And it's not enough. And so I just think that the way she presents it, especially like only using one slide. So she puts all three of the quote unquote passed out pictures on one slide. She doesn't show the slide of the cocaine. She doesn't show the video, but at this point, the jury knows it. They've seen it. And she's not going to go over it again. I thought that was effective. I don't think she needed to put those up there. Everybody knew what it was. And then the dissecting of the text messages, because this is just one of many text messages, but she kind of rolls them all up into one. And it's well done.
What do you think about making bullet point with the name of the witnesses? Because I think that the Amber team generalized witnesses, employees, and she named every person that testified during all the closing. Really well done, because when you says witnesses, okay, can be 2, can be 20, but she making a number, it make it stronger. People supporting Depp and not supporting her. What is your perspective regarding that?
Well, let's show that clip. It's actually the next clip. So that's
sorry.
a perfect segue to that clip.
I was thinking the same.
Sorry. We're going to the next one.
It's perfect. Yeah, no, it's perfect.
Well, sometimes mistakes coming for a reason and look like it.
Before she showed up to that courthouse with a mark on May 27th. And the very next day, after Ms. Heard walked into court with what appeared to be a bruise on her face to obtain a domestic violence restraining order against Mr. Depp, Ms. Heard was photographed laughing with her best friend, fresh-faced, with no bruise on her face. The mountain of evidence that Mr. Depp abused Ms. Heard is simply not there. What we have is a mountain of unproven allegations that are wild, over the top, and implausible. And you can't pick and choose which of these wild allegations to believe and which ones to disregard. You either believe all of it or none of it. Either Mr. Depp sexually assaulted Ms. Heard with a bottle in Australia, or Ms. Heard got up on that stand in front of all of you and made up that horrific tale of abuse. Either she's a victim of truly horrific abuse, or she is a woman who is willing to say absolutely anything. It is disturbing to think that Ms. Heard would make up the horrific tales of abuse that she testified to in this courtroom. But this case doesn't come down to whether you believe Ms. Heard or you believe Mr. Depp. This case comes down to whether you believe Ms. Heard or you believe Mr. Depp, Christy Dombrowski, Sean Bett, Malcolm Connolly, Travis McGivern, Starling Jenkins, Keenan Wyatt, Dr. Kipper, nurses Debbie Lloyd and Aaron Filati, Tara Roberts, Ben King, Kate James, Kate Moss, Dr. Colber, Morgan Knight, Morgan Tremaine, Officers Melissa Sines, Officers Tyler Haddon, Officer William Gatlin, and Beverly Leonard. What Ms. Heard testified to in this courtroom is the story of far too many women. But the overwhelming evidence and weight of that evidence shows that it's not her story. It's not Ms. Heard's story.
Counselor?
Well, this is the one of the big takeaways from the closing, right? Everybody remembers this list of people on one side and then Amber Heard on the other, all the Johnny Depp witnesses, and we know from the rest of the closing that Amber Heard's team gets up and says all these witnesses are just paid, but it doesn't go well. it's just not believable that every single witness on Johnny Depp's side is just doing this either because they're paid or they want to do it because of Johnny Depp, especially when you have people like the officers or Kate Moss, these independent people who have really no axe to grind. So I thought the technique was very strong. I thought it was well done. Amber Heard's lawyers, and I think it's in rebuttal, eventually get around to listing their witnesses, but it just doesn't play as well as it does here, because I think it's a little too little too late. The whole pick and choose theme, so that was a big part of their case, which is you either believe her completely or you don't believe her at all. And had Amber Heard's lawyers been able to own up to some of her lies, they may have been able to get the jury to do just that, which is pick and choose abuse allegations. And all they needed was one. So in theory, all they needed was one. And so I think that it was very well done by Depp's team, which is to say, and I've seen this in trial practice before. It's done with a simple analogy, which is if a roach touches a peanut butter sandwich, do you eat the rest of the peanut butter sandwich or do you just throw it away? Well, this witness, and say it's a government informant, or here it's Amber Heard, lied about this in this one instance. So everything they say is not credible. Well, we all know that in real life, people lie about some things and they don't lie about other things, or they embellish some things and they don't embellish other things. It's not as simple as just throw away the witness. And that was a huge problem with Amber Heard's defense, was they allowed the jury and really pushed the jury to throw away all of Amber Heard's testimony when some of it was actually credible and some of it wasn't. And Johnny Depp's team did a good job here with the theme of you can't pick and choose. So those are my thoughts about this clip. But two different things happening here.
Yeah, and again, I think there was brilliant name people, because if in any case you forgot everybody who talked about him, because again, after 6 weeks get diluted, now you have names and names that resonate with you. So now you can go the checks fact, like it's a lot of people talking good about him.
Yes. And I think here it's like when Camille is talking about this, it's not just what Johnny Depp said or Amber said. It's about what Amber said versus what Johnny Depp and all the witnesses said about it.
Correct. Yeah, no, it's a very, very powerful moment in her closing.
Okay, we have more videos and getting super excited. Okay.
Over these last several weeks to listen to Mr. Depp, to his friends, to his family, and to so many others who have come forward physically in this courtroom, some from a very long distance, to tell you the truth, and to finally, after so many years, to correct the record. As Ms. Vasquez said, you have now come to know the real Amber Heard. Scary. We also told you at the start of this trial that you were going to come to know the real Johnny Depp, not the many characters you've seen him play so wonderfully in the movies, but the man himself. We kept that promise. You've met the real Johnny Depp. You have heard that Mr. Depp came from humble, very difficult beginnings. You have heard from Mr. Depp's big sister, who's here in the courtroom today, Christy Dombrowski, who told you how Mr. Depp grew up in a deeply troubled household with a mother, Betty Sue, who was physically abusive and mentally cruel. As Ms. Dombrowski testified, one of the names that Betty Sue called Mr. Depp when he was a little boy was One Eye, because he had to wear an eye patch for some time. His mother used to hit his father and the kids, including young Mr. Depp. And when his mother got violent, Mr. Depp would retreat and find a place to hide. Sometimes he and his sister Christy would find a place to hide together. Mr. Depp never hit back. And like his father, he either stood up and took the violence or he retreated from it.
Counselor?
So this is a huge part of every trial, which is presenting your client's personal story, right? So who they are, why you should find for them, is always the backdrop to who they are. And here, the way that they make it relevant is by bringing up his childhood abuse, and it dovetails into the allegations. It doesn't always, but to the best you can, you try to. And this gets back to the hero's journey, which is the adversity that your hero takes on throughout the course of their journey, often starting at a very young age. And so I think that they do a good job of presenting it. They're pretty concise about it. And even though I don't think it's totally persuasive that, well, Johnny Depp didn't commit abuse because here he is when he's a child being abused and he would always run away. He didn't get back to the abuser, but it does introduce him. It does create some sympathy, especially towards the end, which is that he took care of his mom in later years and didn't leave her out in the cold. And so I don't know if that would.
He's not a vindictive person. I think that was the message, even though she was cruel with him at the end, when the sister testifies, says he never wanted her to be on a hospice. She wanted to be home and take care of her, and he take care of everything. It's like, okay, if he's capable to forgiveness to somebody who supposed to raise him and take care of him, like your parents here, like your mother, and he's not vindictive to that woman, why are you going to believe that he's capable to hurt someone who he just met and is nothing in his life?
Yeah, that's a really good point. I mean, that's yeah. I mean, he doesn't come right out and say it, but that's certainly a message to take from it. I think that's
remember that most of the jury were women. Asian
Yeah.
women who have the risk. Okay, we need to understand from the behavioral standpoint, Gessin. Most of them are Asian descendant, so that can be Chinese, Indian, whatever. The traditional cultural thing says that we need to respect our superiors and our family and our mother, because it's the one who gave us life. That's how what happened in Asian. So when they say that she was so bitter, so bad with him, automatically in your paleo brain, like, oh, if he didn't do that with his mother after everything that she does to him, why he's going to do it with Amber Heard? I bet you, my right, Pinky, that happened. Behavioral wise, when I was listening to and reviewing who are the jurors, I'm like, that makes sense.
Yeah, it might resonate with those jurors that have that sort of background. I don't know if it's going to resonate with white male, quite frankly, because I think they're just going to be like, well, that's just mom. I mean, we all have, moms that were.
I would have been my mom. Most men say, like, I would have been my mom after what she did to me.
Yeah, I grew up in a Jewish household. They don't beat you, just guilt you to death, right?
Oh, so, I'm Jewish too, so I'm with you. That's the reason I know so much about guilt and respecting family. I learned that. Oh, Jesse, we learned that from the day we were born.
Yeah. So it's an amazing mind trick, right? Because we learn to beat up on ourselves. So but yeah, no, I think he does it in a concise way. I mean, generally, look, this is the first time that we've had a clip from Ben Chu, and he as smooth as Camille Vasquez is, Ben Chu is sort of choppy. He reads a lot. He's not. What I'm surprised that he's actually using a legal pad as opposed to typed out notes. I'm just surprised that he doesn't have typed out notes, that he's using a legal pad. He does better in closing than he did in opening. In opening, he was very choppy and turbulent. He was reading His delivery was stuttered. Closing, he's better. He's smooth. He's a little smoother, but not nearly as smooth as Camille Vasquez, which is surprising because Ben-Shu is a lot more experienced than Camille Vasquez. He's done a lot more trials. He's got a deep trial resume, but here we see it in full force. So I'm just wondering about his delivery, and but I suppose it creates authenticity in some sense. But I get the sense that he's not practicing these openings and closings before he delivers them. I think he's just doing it first run in front of the jury. Quite frankly, that's my sense.
How long do you think they worked all the team together before to go to this trial? How many years?
Well, okay, so Camille Vasquez is based in Orange County and Ben-Shu is in DC. So I get the sense that they're not working together as a team, as a trial team generally. I get the sense that they're put together for this one case. So and Camille Vasquez is not, I didn't see a background in trial work, like public defender, prosecutor, something like that. So I think she was probably plucked for this one case because, quite frankly, you have to have. I just can't see a male lawyer questioning Amber Heard the same way, and the fact that they were able to get someone that's only a year, I think they're a year off between Amber Heard and Camille Vasquez, is a huge bonus because there's just not that many people that can deliver the way that she delivered in this trial at her age. Under 40 is very young for a trial lawyer, very young. It takes 10 years of just in the trenches, just to get a sense of what the courtroom's about. And so it's really impressive what she did here. Now, of course, she's got 9 lawyers behind her working on the what she's going to say and what she's going to do, and that's why I think she sticks really strongly to the script. But she delivers, and her cadence is good, and she's practiced, and her crosses were good, and so it was just, it was really well done. It's very impressive, and when you put her up against Ben-Shu, who's quite experienced and who's probably making the final calls on what content gets in and what content is left on the floor, because there's a lot of stuff left on the cutting room floor in a trial. And maybe that's why she's a little more polished than him, because he's sort of working on the content and she's working on delivering the content. I don't know how their trial team worked, but I'm guessing that this is a trial team that was put together for this trial, and that's it.
Because everybody was commenting about the relationship between Ben-Shu and Johnny Depp, and how it was like a relationship between a father and a son. And I think that part of the choppiness on Ben doing the closing, it's happening here in your courts more than the delivery, physically the real delivery. So I think if it's not a real emotional chokiness, he's playing that card when he's talking about the relationship between Johnny Depp and the mom purposely.
Potentially, but he was a little choppy in opening too. So he could just be emotional about this case. That happens. It's hard not to have a special connection with a client that you take through trial, because this is a civil case. So, Johnny Depp isn't going to jail if Ben-Shu loses, but there's a lot of money being invested. There's a 50-year, 40-year career that essentially is on the line. And it's that when you have stakes like that, there is a very special bond that's created with a client and an attorney under those circumstances.
I have seen lawyers cry when they win, and I see lawyers cry more than the clients when they lose too.
Absolutely. It's, they talk about quote unquote method acting and what that means. And, in a sense, I think every lawyer has to leave objectivity behind and really embrace the narrative in the same way that a method actor embraces the character wholeheartedly. And if you don't, 12 jurors off the street are going to see through you. I mean, if you don't believe your own narrative, you're toast, quite frankly.
Okay. Are we ready for the next video? Any more comments?
No, I think that's it. So that was our first introduction to Ben Chu. Let's watch another one from Ben Chu.
Figures like Winona Ryder,
Here we go.
Yeah,
Kate Moss, and Vanessa Paradis, with whom he spent 14 years together and with whom they had their children. Before Amber Heard, ladies and gentlemen, no woman ever before Amber Heard ever claimed that Mr. Depp raised a hand to her in his 58 years. And no other woman since Ms. Heard made that false claim back on May 27th, 2016, and repeated it in her December 2018 op-ed. Has any woman come forward since? This is Me Too without any Me Too. To the contrary, ladies and gentlemen, you heard Kate Moss 2 days ago testify. This is a woman who has never testified in any proceeding, ever. A very private person. Testified that Mr. Depp never abused her and that Ms. Heard lied to you. And she lied to you twice when she told you.
Objection, Your Honor. That Ms. Sure.
And he did not and does not deserve to have his life, his legacy destroyed by a vicious lie. And this is, as Ms. Vasquez said, this is the 6th anniversary of that. There is a world of difference between having substance abuse problems and being a physical abuser. Ms. Heard falsely accused Mr. Depp of beating her. That was her first allegation, and you know why, and you know that wasn't true. Then, years after the fact, for the first time, she accused him of raping her. The lies have grown and metastasized over time, and they need to be stopped. And those false accusations have caused more harm to Mr. Depp than her fists ever did.
Okay, Counselor, what happened
Okay. So this is a really strong point that Ben Chu is making to the jury, which is that we know the Me Too stories. We know the Bill Cosby. There's over 60 over 60 people have came forward. Weinstein, God, who knows how many, countless. With the Me Too cases, there tends to be multiple victims. And Ben Chu's point is there's no multiple victims. You heard from Kate Moss, you heard about Vanessa Paradis, you've heard about Winona Ryder, you've heard from these former lovers, famous lovers of Johnny Depp, and there's no claims of abuse. Amber Heard's the only one. And so the way that he wraps that into a theme, and themes are a very important part of trial advocacy. They're, like I said, they're what you do to arm the jury with points that they're going to make. But more importantly, it's if you have the skeleton of a case, which is the narrative, the flesh on the bones is the themes, and you need themes to color your narrative to the jury. And so his theme, of course, the most famous theme of all time is from the O.J. Simpson trial. If the glove doesn't fit, you must acquit. Here, Ben Chu is creating a theme which I think is very, very, very potent, which is Me Too without a Me Too. Now, I don't know if I would have used that exact language, but the point is very strong, that there's nobody else. And he presents it in a clean way. We've talked about him. I would have leaned into it a little more. I would have, I think, hopefully been a little smoother in the delivery of the theme. Although it's a theme that we've heard before. I think he may have actually said it in opening as well. which is what you want to do. You want to wrap these themes in, like you say, into the hourglass in both opening and closing, primacy, recency. But he does it, pretty solid presentation. And I think that this is a very important part of their case.
Elba, I don't want to interrupt anymore because I don't want to make questions before videos happening.
No,
Okay.
I want to keep going. It's really interesting.
Okay. Okay, let's see if I don't mess it up again with the videos.
And because of what she said, Mr. Depp will go to his grave knowing no matter what he does, no matter the outcome of this trial, there are people who used to look up to him who now believe that he beat a woman, which is the worst thing you can say about a man. Beyond the personal and emotional effects of Ms. Heard's lies, their impact on Mr. Depp and his family, the damage she inflicted on his reputation and career is undeniable. There's an old saying that a good reputation takes a lifetime to build, but only a second to destroy. Mr. Depp spent, in fact, a lifetime building his reputation as one of the greatest actors and movie stars of his generation, an iconic figure respected and liked throughout Hollywood and recognized and admired throughout the world. You heard evidence from Jack Wiggum, who was here today, Mr. Depp's agent, who explained that Mr. Depp, quote, was very well regarded and respected by peers in the artistic community, unquote. And you heard further testimony from Mr. Wiggum that Mr. Depp had a deal with Disney to play Captain Jack Sparrow in the 6th movie sequel of the Pirates of the Caribbean franchise for $22.5 million.
Counselor?
Okay, so this is the damages portion of the closing. It's actually the weakest part of Johnny Depp's case is damages. Traditionally, defamation is very hard to pin damages to. This isn't a personal injury case. Person gets hit by a car, they've lost wages. We can quantify how long they weren't able to work. We can quantify what their hospital bills were because there's of course invoices from the hospital. It's the pain and suffering that's a little difficult to pin down. But for the most part, in a personal injury case, we can easily come up with a figure. Defamation, somebody's reputation, it's really difficult to quantify. Here they try to anchor the damages to the lost revenue from Pirates of the Caribbean 6, but it's really not that persuasive because there was a Disney executive that testified for Amber Heard that said that there was no deal. So Johnny Depp's team is, well, there was an oral deal. I mean, come on. An oral deal
It's Hollywood. You don't do that by talking on the phone. You put your fingerprint on that.
22 million? Come on. Yeah, so look, it's the weakest part of their case. He does a good job. They do their best. I'm not a huge fan of the cancer analogy, the metastasizing lie. I don't think I would have used that analogy. I think analogies are very important, and I think that they could have come up with a different analogy. Cancer hits a little close to home. People are saying, well, yeah, your reputation's, messed up, but I'm going through radiation. I'm going to lose my life. I mean, I don't know how many jurors have gone through cancer or had family members that have gone through cancer, but I would not have used that analogy. But it didn't seem to affect them. I mean, they were able to get 10 million in compensatory. So 10 million is pretty good. So it didn't seem to affect the compensatory. I mean, they didn't get 22 million, which they didn't quite make an ask also, which is unusual. Usually lawyers make an ask. They didn't make an ask, but they brought up the 22.5 million. The jurors clearly didn't go with that, but they still gave a significant amount. I don't think that 10 million is tied to anything. Normally you can trace it back to something, either a damages expert or an ask by a lawyer or something. This is just, it's untethered. And look, this may be going back to horse trading. Maybe they wanted to give 22.5 million, but the one juror that was holding out for Amber Heard said, no, let's cut it in half and give Amber Heard some money. that could have happened. Jurors do that all the time. So I thought that the way that he presents it is fine. It's a weak part of his case. He has to do it. He has to get in front of there and do it. And I thought he did it pretty well, but for that one mistake with the cancer analogy, I would not have used.
Yeah, because this is not spontaneous that you're
No.
testifying and something come up. This is prep. So you know what? They're so careful in everything that I have done. They maybe remember, for the people who doesn't know, they have all the information about the jurors. You don't have it as a witness on TV, but they as lawyers, they have all the info. I don't know if anything that we're going to know about one of the jurors that maybe was the most difficult to break or something like that can be related, because like you said, when I hear like, what the heck is going on with this team, is out of the scope of safetiness or risk control they've been doing, talking about the cancer. We caught the same. We were talking about that, Gessi. What do you think?
It's possible. It's possible that they could have had some research on one or two of the jurors that they had battled cancer and survived cancer, and they want to personalize it to those jurors. It's possible, but it's still really risky, even if they had that information, which they could have absolutely gotten that information during their research. I mean, jury selection lasted for a little while and you get a lot of information, but then you have 6 weeks during the course of this trial to get additional information before the closings. It's possible it was targeted, but still risky, even if it was.
That he was never abusive to Amber on even one occasion. Think about the message that Mr. Depp and his attorneys are sending to Amber, and by extension to every victim of domestic abuse everywhere. If you didn't take pictures, it didn't happen. If you did take pictures, they're fake. If you didn't tell your friends, you're lying. And if you did tell your friends, they're part of the hoax. If you didn't seek medical treatment, you weren't injured. If you did seek medical treatment, you're crazy. If you do everything that you can to help your spouse, the person that you love, rid himself of the crushing drug and alcohol abuse that spins him into an abusive, rage-filled monster, you're a nag. And if you finally decide that enough is enough, you've had enough of the fear, enough of the pain, and you have to leave to save yourself, you're a gold digger. That is the message that Mr. Depp is asking you to send. But he doesn't stop there, because in Mr. Depp's world, you don't leave Mr. Depp. And if you do, he will start a campaign of global humiliation against you, a smear campaign that lasts to this very day. He will do everything he can to destroy your life, to destroy your career. That is what they're saying, ladies and gentlemen. And that's what they're trying to get you, the jury, to be an accomplice to. But it's not surprising, because Mr. Depp cannot.
Counselor?
Well, as good as Camille Vasquez was at empowering the jury to give Johnny Depp his life back, Benjamin Roddenborn was as bad as trying to convince the jury that they're an accomplice to a scheme to globally humiliate Amber Heard. Look, I don't think that this is a great way to convince the jury that your client's narrative is the true one, is the one to go with. Using the word accomplice to if you agree with Johnny Depp, or you believe Johnny Depp, or you find for Johnny Depp, you're an accomplice. It's too far over the line. It's not empowering. It takes away. You really want to be giving the jurors the respect and dignity and grace that they have. You want to. They're the ones that hold the cards, and so by coming up with this theme of accomplice, you're really taking that out of their hands. it's just, it doesn't play well. That's what I thought about this clip. And this is how he starts his closing, is by taking away, which is very different than how Camille Vasquez starts, by empowering. That was the number one. Number two, look, in general, Benjamin Rottenborn is good in court. He's maintaining eye contact. He's got pretty good hand movement. It's a little distracting, but not crazy. I would have preferred left hand movement. I think it's a tick that he does. But he's clear, he's concise, he maintains eye contact, he stays on, he appears to stay more linear than Elaine Betancourt does, and we're going to talk about her in a bit. But those were my thoughts about this clip.
I have a friend who is really no filter and says he started burping before the dinner. Like, you know what? That's horrible, but it's
like
true.
That. Yes.
Like, what the heck is wrong? You need to start with the entrance, first plate, salad, soup, and after the first block, he started burping. Like, okay, nobody need to agree, but I think it was funny when he was reviewing the videos with me. Like, what the heck is going on with this guy?
Yeah, no, I agree. It's interesting too, because he is a very experienced trial lawyer and a very accomplished trial lawyer. But I was just really surprised that this is how they began, and then it gets a little worse, and we'll talk about what happens in the next one.
Oh my God! You build in the excitement. Okay, next one.
That he was never abusive to Amber on even one occasion. Think about the message.
Okay, it was the same one. Now again.
I just want to say something before we go to the next video. It's like you said, Camille start with giving the power to the jurors, but now we see, like, okay, you are the partners in crime, so it's the guilt in the shoulders. So I think it's like you said, it's not a good way to start.
No.
Okay, I'm gonna miss it out.
And you cannot simultaneously protect and uphold the First Amendment and find in favor of Johnny Depp on this claim. You simply cannot. You have to decide, should someone be able to write an article like that in the United States of America without being sued successfully, without having to go through the hell that Ms. Heard has gone through? So let's talk about that. And to do that, we get to explain a bit more about the law that you have to follow. This is the op-ed piece. I'm not going to read it to you again. You heard me read it to you in opening statements. And I would urge you, when you're in the deliberation room, read it. Read it again. And I know we focus on it, here and there over the course of the trial, but the vast majority of this trial has not focused on these words, on this piece. This is obviously the paper edition. There's the online edition as well. Now we get a chance to discuss with you exactly what you have to find about this article. Let's try this again. This is one of the jury instructions that you'll get. And I've been so looking forward to being able to actually explain to you, as the judge read all the instructions to you this morning, and I know it was a lot, but we've been looking forward to being able to explain to you what you're here to decide. Because I imagine for some of the case, it's been kind of unclear. What are you being asked to decide?
Counselor?
Yeah, so right after he makes that introduction about the accomplice and introduces the accomplice theme, he then moves right into jury instructions and admits that, oh, well, we've been waiting for this opportunity to talk about the law to you. Look, I think every lawyer thinks that during the course of a trial when the facts are not on their side. There's a famous quip: if the law's on your side, argue the facts. If the facts are not on your side, argue the law. And if neither's on your side, bang on the table or something like that. But the point is that the law is on their side. The law is on Amber Heard's side, and they clearly were itching to get the jury instructions, and that's what's put up there on the slide in front of the jury. But to do it at the very beginning of your opening is really counter to the way that closings are usually done. Usually what you do is you argue the case, you argue the inferences from the facts, and then at the very end, after you've made the argument, you put up the jury instructions and you go through the jury instructions and show how the law supports your arguments. Or you can put up a jury instruction earlier, but what you want to do is put up an element of the jury instructions and argue the evidence under the element of the jury instructions. So that way that the argument is anchored to the law. But to just put up a jury instruction with a bunch of words, first of all, the jurors are probably sitting there trying to read the instruction, and then he's talking over it. He's not anchoring it to one particular
actually,
argument.
you mark it before with Camille that how she will pause. In this case, Ben is doing all the opposite, not allowing people neither to pay attention to him, neither to the word. So it's great that you mentioned it before, because now we can do how it cannot be done or shouldn't be done.
Yeah, and also look how wordy that instruction is. I don't like to put up more than one sentence for a juror to have to read. And you'll notice that Johnny Depp's lawyers did a great job of that, because they did put up a long text, but then they underlined what they wanted the jury to read and what they were talking about. I actually pop those out usually, so that way I have the text in the background, so the jurors actually can't read the text. They know it's the text, but then I have a call out. And that. So the next best thing, I think, is underlining it. And maybe they weren't allowed to call out. I don't know. I mean, these are very sophisticated trial lawyers. So you would imagine that they had at least discussed that potential graphic.
Maybe they lost because the juror didn't understand the instructions.
Well, the jury certainly disregarded the law. That is without a doubt. That is without a doubt.
That's a good.
But, look, it happens. I mean, generally, I think jurors follow the law, but they disregard the law. It happens. But yeah, putting up an instruction with all these words it's not helpful to their cause. And once again, they could have put up a call out of this instruction, the one aspect of this instruction they wanted the jurors to focus on, but they're not doing that. So.
Okay, let's go to the next one.
And you cannot simultaneously protect.
Here we go. Yeah, that is the right one. Now I got it.
We talked about the monster. You heard Mr. Depp get on the stand and say that was Miss Heard's term. She made it up. That was what she used to refer to him when she was nagging him, because she didn't want him to have a good time. She didn't want him to have a beer once in a while. That's what he's implying. But no, this was a term created by Mr. Depp that she heard for the first time in 2012 after he slapped her 3 times across the face and said, "I thought I put the monster away." And after he sat up here on the stand under oath and told you that she made that term up, we look back at his texts, the writing at the time. The first text is after Australia in 2015, during a period of sobriety, a short-lived period of recovery for Mr. Depp, when he told Jerry Judge, his bodyguard, all I had to do was send the monster away and lock him up. Remember, he texted Elton John, or sent an email to Elton John in 2012, referring to himself as the monster. He tells Dr. Kipper, the doctor to whom he's paid millions and millions and millions of dollars, "Thank you, my darling Kipper." He says, "I've locked my monster child away in a cage deep within." He tells Stephen Deuters, you know Mr. Deuters, he liked to text Mr. Deuters. He tells him, "She thinks my Peruvian period," which is a reference to cocaine, he admitted to that means him using cocaine, "has made me a monster and that I am ruining the relationship." Imagine that, someone actually thinking that maybe the impact of alcohol and cocaine is ruining a relationship. How dare she? He says, "Need to discuss the news helicopters. The monster, I want to shoot a motherfucker, but don't worry, the monster is not involved." Mr. Depp knows that he can turn into a monster. He knows that. He knows that. He got up here on the stand and tried to deny that to you. Talk about lack of accountability. Let's see the monster. Let's see the monster in the flesh.
What happened? What happened? Nothing happened this morning, you know that?
Were you in here?
No.
So then nothing happened to you this morning?
Yeah, you're right. I just woke up and you were so sweet and nice. We were not even fighting this morning. All I did was say sorry.
Did something happen to you this morning? I don't think so.
No, that's the thing.
You want to see crazy? I'll give you fucking crazy. That's crazy. Oh, you're crazy. You're crazy.
Have you drunk this whole thing this morning?
Oh, you got this going? You got this
I
going?
just started it.
Oh, really?
Yes.
Really? See that shit on you,
No,
motherfucker?
I didn't. You were smashing shit.
Bye. Ass.
Counselor?
Okay, so this is what I would have used to start the opening. I would have started with the monster. The monster is, look, he uses the word himself. He uses it in text messages. Apparently he uses it in an email. You can see it on the video. I would have started with this. And what I would have done is I would have anchored the entire case, not to Amber Heard's testimony, but to the video and the text messages. And I would have owned her basically framing everything else, you know, the TMZ stuff, the restraining order, and had they done that, I think they could have convinced a jury that at least this one instance is abuse, and that, you know, maybe she embellished the other instances of abuse, but you're seeing it in real time. And they could have buried her lies within this monster theme. They could have said, he could, you know, like Benjamin Rodward could have gotten up and said, here's the monster, you know, can't, you know, Amber Heard may, you know, if you believe Amber Heard lied about the, you know, tipping off TMZ, or the you know, using a bottle to be, you know, about the sexual violence of the bottle, or whether or not she threw, you know, whether or not his finger was cut off by a vodka bottle, and all of that, and just said, look, see it in real time. I think they may have had a better shot at defending this case. And they had the opportunity. They have it. It's just amazing to watch how they squandered it. This should have been the first thing. I mean, they may not even had to have said anything. Just get up and play the video right in the beginning of the closing. And I, quite frankly, I would have left it up. I would have left it up. But
Jesse, for the people who doesn't know, this is not evidence like this video that they were presenting during the trial and a statement, and they didn't have before. So they have time to prepare the material for the closing even before the trial started, correct?
Correct. Correct.
So
they have time.
Okay, Elba, any questions? Or we're going to the next one?
Let's go to the next one. I want the next one.
Okay, you know something that I don't. Oh, this is Arlene. That's the reason you want it.
Yes, that's why.
I'm in the right video?
Yes.
Okay.
Go really fast and try to go as quick as I can so that you can get a break from us and go make your decision. I know you're probably itching to do it at this point. But this is very important to us, and we appreciate your listening, and we appreciate your being here. I'm going to stay on this slide for a moment, and there's something that's very important on this slide that hasn't been brought to your attention by Mr. Depp's team. When you see the actual damages, go down to the last paragraph, if you will. It says, Mr. Depp cannot recover damages for any harm that occurred after November 2, 2020. Do you all see that? So what Mr. Depp's team got up here and told you through Mr. Chu this morning has nothing to do with this case. He had his chance in the UK. The lawsuit was filed June 2018, 6 months before the op-ed. The trial was July 2020. The process ended, according to Mr. Marks, their expert, on November 2, 2020. And his damages stop then. He can't get reputational damages. He can't get his legacy back for his children. He can't get anything.
Oh, sorry. My fault. My bad.
After that day from you. You can't restore his reputation. You can't give him anything. They didn't tell you that, but the court told you that. And that's a very, very important thing here. He told his story. He had his opportunities. He had his full opportunities to do all of that. And he came in here and lied to you and said he's here to get his reputation back. It's just one of many lies in this case, but it's a really big one, because here we are, 6 weeks of your time, precious time, 6 weeks of this court's time, for what? For nothing. Only to go after Amber. That's psychological abuse.
Counselor?
So there, poor Elaine Bretterhoff, right? She really takes the flak. Let me start by saying that, again, you're dealing with a very experienced and well-respected trial lawyer here. Part of the reason why she's, I think, scattered and moving quickly is she has way less time than she anticipated. So Rottenborn ran long. She's got to move quickly, and they end up only leaving 6 minutes for rebuttal. It's very frequent judges put people on a clock, and not just for closing, but entire trials are put on a clock. And it's very difficult to work under those constraints. I've been on a clock, and it's tough. And I think that's what you're seeing now is Bretterhoff is feeling the pressure, the time pressure. Now, that said, this is a hot mess. So she starts off, she was going to do something different. And then she gets up there and decides that she's going to focus on that one statement in the jury instruction. Now, the problem is that it doesn't really make a lot of sense. The fact that they can't recover for reputational damages after November 2nd, 2020 has nothing to do with whether or not Johnny Depp can get his legacy back. Whether or not he can recover reputational damages after November 2nd, 2020 is completely divorced from getting his legacy back, which is clearly something the jury can't give him. That's whether or not society decides to give him his legacy back.
You have 6 minutes to do your rebuttal. Pick and choose what is the most important thing you need to defend. Not talking about Johnny Depp legacy. What do you think?
This is not their rebuttal. This is their closing. closing. So they actually have more time in the closing. They've split the closing, but there is going to be a rebuttal portion that she knows is coming, that she's trying to save time for. And it's the rebuttal. The reason that they both get rebuttals in this case, which is unusual, is because they both have claims against each other. Normally just the plaintiff gets rebuttal, but here they're both plaintiff and they're both defendants. So they each get rebuttal, and Johnny Depp's team ended up getting, I think, 39 minutes for rebuttal, and Amber Heard's team got 6, which is a lot less. Now, their counterclaims weren't as important, so it wasn't as critical for them to get rebuttal. But as you'll see, and we'll talk about some clips for rebuttal, Johnny Depp's team doesn't focus just on they use their rebuttal to in a way that is not specifically tied to their claims. They address Amber Heard's counterclaims, which in theory they're not supposed to do, but we'll get to that in a minute. So what happens in this clip is she points out this one line in the jury instruction and then takes it too far, and then she goes back to this theme of the jury being an accomplice, and it's just not persuasive. The way she does it is she says that this case is psychologically, basically psychological torture for Amber Heard, and it's a way for Johnny Depp to torture her. And again, ergo, she's, the jury is an accomplice. So now they're an accomplice to torturing Amber Heard, and before they were an accomplice to demolishing the Me Too movement. I mean, again, you're taking the power away from the jury in a really aggressive way. And it's surprising too, because as I said, Brederhoff is a well-respected trial lawyer who undoubtedly has empowered jurors in closing and opening in many other cases. But here you can see a level of frustration and stress is coming out, and it's not a particularly effective way to begin an opening.
Apparently both has weak beginnings, correct?
Yeah, both have weak beginnings, and they both start out the same way. And I don't know if they're doing it on purpose, quite frankly. I don't think it's calculated. I think his was. I think Rottenborn's was calculated. I don't think hers is calculated. I think they've spent so much time with this theme of accomplice. I'll call it the accomplice theme, but really it's making the juror a part of taking something from either Amber Heard or the movement in general, that they can't get away from it. They just can't help themselves. It's unfortunate, but it's a structural error with the entire case. That's what you do when you dive into Amber Heard's narrative and you embrace it wholeheartedly. It should not have happened from Jump Street. A little tongue in cheek there.
Elva, anything?
Yes. I want to add something, because when she said, like, if you can read the last sentence, she said, if you will. Like, okay, you are telling me that I need to read it, but if I will, like, what I do here, you need to give me a call of action.
Yeah. Agreed.
Welcome to our expert in language.
Yes.
Do you know, Gessi, the top expert in linguistic and statement analysis in the world was born and raised in Israel, Aminoan Sapir, and he developed this system in English, even though he's not speaking English. He came to the United States in 1987 to teach the forces, CIA, FBI, and lawyers how to use a statement analysis, how they caught the Una Bomber on the 90s. And he developed the system in English, not speaking English, because he says, when English is not your first language, it's easy for you. You cut things that other people don't.
It's amazing. It really is.
We both studied with him. Okay.
Go really fast and try.
We know you're going fast, honey. You told her already. Okay.
There was an awful lot of it, and she put it in great detail. Now,
is that I'm on the right video? Okay, let's start again.
There was an awful lot of it.
Yeah, I think I'm okay because I'm messing up with the
This is
videos.
13,
Okay.
right?
I think, yeah, we're on 13.
And she put it in great detail. Now, let's talk for a moment about the motive. They have said that she has created this whole hoax, and I think Ben's done a nice job of showing how that can't possibly have been. But what would Amber Heard's motive be for creating a hoax, or creating any of this, or making any of this up? That's a big question here. They call her a gold digger, right? But she obviously couldn't have done it for the money. Because first of all, remember the testimony of Laura Wasser, the divorce attorney. She said that California is a no-fault state and community property. So Amber doesn't have to have an abuse. She could have divorced him for irreconcilable differences, for abandonment, for adultery, for anything. She doesn't need an excuse. And she gets 50% of whatever he earns during the time of the marriage, unless they had a prenup or a postnup. The testimony from Michelle Mulrooney was that Amber completely cooperated with the prenup and the postnup, but it was Johnny Depp who, and you already heard from Ben, he called her up and fired her. He didn't want a postnup or a prenup. So she's entitled to 50% of everything he earns during that time. Now, we have Plaintiff's Exhibit 936 in evidence, and look at page 69. It says how much he made in 2015. It was $43 million. Remember Mr. Spindler, Depp's expert, who said that he made $22 million in 2016. So you got $65 million.
I only want to say this. With that amount of money, I get lost. I cannot count how many series. Like, how he can be bankrupt with that amount of money? God, Lord.
He goes through money like what? Well, this case is a good example of how he likes to blow money. Because I honestly, if Brown Rudnick, which is Ben Chu and Camille Vasquez's firm, doesn't have a letter in there, covering them on the potential loss here, then that would be insane. I can't imagine advising Johnny Depp to go forward with this case without some sort of, covering themselves. It was a very risky case, very risky, but it paid off. Look, actually it didn't, because Johnny Depp's probably never going to see a penny of that money, because I don't think Amber Heard has the money.
No, the lawyer Elaine says yesterday in one of the interviews, she doesn't have the money. So we're gonna, oh my God, I forgot the term when they're gonna sue again.
Well, they're gonna appeal.
Appeal. I'm sorry. Appeal. They're gonna appeal.
They'll appeal. And if it eventually goes to a collectible judgment, she may declare bankruptcy. So to discharge the judgment, well, in any case, whether or not it's dischargeable in bankruptcy is another issue. But getting back to this clip, so they're trying to bring up this point, like, well, okay, there was no financial motive for her to lie and to, make up the restraining order, to make up the op-ed article. So what was her motive? And it's unfortunately it should have been done differently. Let me put it that way. It's always good to address motive. Okay. The problem is it's so obvious what the motive is, right? Okay. So it's not money. Well, although that was clearly a part of it because she didn't donate the money. But the other motive is fame. Right. I mean, that's the most obvious motive, is that she's choreographing this restraining order. She writes this op-ed article right before her movie comes out. It's promotion.
One of his movies was coming out too. Her movie came first, and that happened when his movie was coming too. So she was getting attention to hers and not to him, because I heard an expert saying, I'm sorry, but it just was like extremely strategic. And he was like, why they didn't explain how the timeline with the ops just happened to help her and obviously destroy him.
Yeah, no, it's a great point. And the way that Bretterhoff does this, I think is unfortunate. If she was going to go after the motive, she should have, well, we get back to the structural error of going all in on Amber Heard's narrative. She should have addressed that much earlier, and she should have done it in a way to say, look, she didn't take him for all he had. She didn't ride his coattails to stardom. She tried to make her own, path forward in Hollywood. She did that by being part of Aquaman and taking on other projects. And yes, she made some, missteps. Blame it on the advisors. The stuff shouldn't have been leaked to TMZ. She shouldn't have, yes, in the end, it was not a great idea to join the op-ed, to write the op-ed article. It was the ACLU that wrote the first draft. It was somebody else who wrote the title. Look, this all could have been done in that way. And then again, get back to the video and say, but was there abuse at any point in the relationship? Yes, there was. And they have an opportunity. She doesn't have to take the flack. She's got publicists, she's got lawyers, she's got assistants, she's got so many people that could have taken the flack for this. But there again, that was a problem of not owning up to Amber Heard being Amber Heard.
The fact that they tried to squeeze to the juror's brain that she was the innocent person, that she has nothing to do, and she was trying to help, and an op using her name was used and she retweeted. Come on, this woman doesn't go anywhere without a publicist. She wasn't even leaving the courthouse when the tweet saying, I'm so unhappy with the outcome. This is a loss for like blah, blah. It was preset. The publicists were doing it. So really, this team would make us believe that she didn't know what was published with her name without the perspective what legally can happen. Come on, we are talking in a level that I don't know many people who can play with, but on the game, on the level of they playing, Johnny Depp and Amber Heard is completely different. Jesse, you represent people like this. You go to court to defend people like this. You don't sign things without going through a complete set of lawyers before to do that.
Yeah, everything's vetted, and hers was vetted. I mean, so Eric George, who I did a case with back in 2018, was the lawyer that vetted the defamation claim. And the case in the case that I was working on with Eric George, we were representing a Hollywood mogul that stemmed from a very well-known case. And I know Eric George. He's a good lawyer. He's a well-respected lawyer. And for him to have vetted this means that there was diligence. It means that there was an investigator that was probably hired to sign off on this. It was, I mean, the fact that Eric George's law firm was involved before publication means that diligence was undertaken. And the fact that they wouldn't use that cover is, quite frankly, it means one of two things. It means either it was a complete misstep and they just decided, no, we're going to go with Amber and hopefully the jury will believe her, or it means that Amber Heard was actually disregarding advice from her professionals. And I don't know which one is true. It's possible that the publicist and the lawyer said, don't do this, and she did it anyway, in which case, that's what she should have said on the stand. Look, I made a mistake, like maybe it was embellished. Maybe I shouldn't have done that. But that's not what happened. And so, we don't know. And we may never know exactly what advice she was given before orchestrating the restraining order, publicity, and vetting the Washington Post article. But it's insane to think that there wasn't like you said, a very high level of diligence on both those. And the Washington Post article was not the most aggravating part of this. It was the restraining order. that's, I think, what really peeved the jurors off was the restraining order.
I have a question for you. If the divorce and everything who happened in the divorce was left on that place in 2016, we wouldn't be here. Amber Heard wouldn't have lost more than $10 million. And Johnny Depp, neither his team couldn't have sued her. The problem was that she couldn't keep herself and she needed to do the op in 2018.
Correct. That's absolutely correct. You can't be sued for statements made in litigation.
In a divorce proceeding, yeah.
You can't it's completely protected. It's called the litigation privilege. It's also another reason why this case is in Virginia and not California, because the laws in California are very protective of First Amendment rights. And it's not just litigation privilege. It's something called anti-SLAPP, which is a strategic lawsuit against public policy or public participation. And it's very strong in California. And I don't think this case would have made it to a jury in California. Let me put it that way. I think it would have been struck down by the California courts under the anti-SLAPP laws.
Sorry, Amber, pay attention to your lawyers because I'm sure you can pay for them. Well, at least she had.
I don't think that one's not her lawyer's fault. That one is good pre-trial maneuvering by Johnny Depp's lawyers.
Yeah, but I mean, she shouldn't be here if she would pay attention to her lawyers. Gessin, I'm sure on 2018, somebody says, don't do it. But she was on the top of the wheel. Johnny Depp was going down. She was on top of the wheel. Aquaman contract, L'Oreal contract. She was under impression she was untouchable, and nothing that is happening now, it wouldn't come back and bite you on the face. And guess what? Karma is a bitch.
Yeah, you hope someone tried to talk her out of writing that article.
I'm sure a lot of people is going to come up says, this is the email. Anything else, or we go to the next one?
Well, I should say it out of adopting the article, because apparently she didn't even write the first draft.
Again, somebody read it for you.
Yes.
Somebody.
Okay, let's see if I mess it up.
There was an awful lot of it, and she put it in great detail.
Here we go. We going to Camille again?
So we're back, and now we're in rebuttal. So we don't have very much rebuttal. In fact, we don't have any clips from Amber Heard's rebuttal. We just have a couple of clips from Camille Vasquez's rebuttal.
Okay, so let's go.
Heard accuses him of. We ask you, we implore you, to render a verdict for Mr. Depp. We ask you to set the record straight, that he is not the abuser she described, and that she is not the heroic survivor she portrayed. And we ask you to tell Ms. Heard that what she did was wrong. Thank you very much, ladies and gentlemen.
Thank you, ma'am. Rebuttal closing.
Counselor?
Okay, so this is the very end of Camille Vasquez's rebuttal. We're actually on the next clip where we're going to go before this, but I wanted to put this in here because it's a strong ending to the closing. She doesn't mention money. She doesn't mention, and she just says, look, tell Amber Heard that she's wrong.
Yes.
I think it's an easy ask for the jury, right?
Yes.
It's very simple. It's like who's right and who's wrong, which plays into their trial strategy very well. And it's well done. What I didn't like was the sort of congratulatory attitude at the end and it's not in the clip, but it's in the footage, which is Camille Vasquez and Ben Chu are essentially fist bumping. They're hugging Johnny Depp. Look, you haven't won the case. You finished your case strong, but that takes away from the jury. That basically says, oh, we think that this is a layup. I didn't like that. I don't think they can help themselves at certain times. They do it. They seem to do it, some frequency. But otherwise, it was a very strong closing.
Believe it or not, Jesse, that the relationship that Johnny Depp showed with his counselors and lawyers was taken by the public more positive than the relation that Amber Heard had with her lawyers. Like that, she was a stoic, coming to the room, no hugging, no like, Amber, are you okay? Taking care of you. Like they saw that they were protecting Johnny. And if the lawyers are protecting Johnny, it's maybe because Johnny is right. When Amber lawyers didn't touch her, they were away from her, is because they don't believe her. It's crazy how sometimes the psychology in people works.
Yes.
Yeah, no, I get that. And and I think
maybe
there's a
they
time
did overdo it.
Yeah, I think there's a time and a place for it. I think right at the end, when the whole jury is still looking at you, is probably not the best time to be congratulatory. But Amber Heard had a lot of problems in this way, right? So her clothes are like it looks like she's like out of Utah or something.
Worse, she
hair,
looked like a Italian
Yes.
mafia, like with the vest and the jacket and the striped shirt, a striped vest, a striped jacket. If you look the Godfather, like the old mafia Godfather coming from Sicilia, she looked like that, or like a Mormon from Utah. Like, what is wrong with her?
I never understood that. And when you're portraying someone who is a victim, or I shouldn't say portraying, when you're representing someone who's a victim, they need to be themselves. And it's so obvious that that's not the way she dresses in real life, because she's not wearing any of that type of clothes in any of the photos.
Nope.
And I understand that it's court and it has to be professional, but Johnny Depp's still stylish. So I think, it's one thing for the lawyers to do it. It's a whole nother ballgame for the parties to do it.
Johnny Depp still Johnny Depp, but presentable in court. Amber Heard is not presentable in court, not presentable anywhere, because it's not Amber Heard.
Exactly. They really needed to take that varnish off of her and just let her be her, which, which is how we ended up with this crazy verdict. And it is crazy. And I'm telling you right now, it is crazy. Just that one video, I'll never get over the video. I'll never get over it.
Again, when I saw the video, like, ooh, I think we lost in here. So when I hear I actually was in meetings and prepping a client when Elba had a break. Like, do you know he won? Like, what the heck? He won? Really? How much? Yeah. We knew that people, the population was on to Johnny Depp, but with the circumstances they have, I'm like you. I was surprised.
Yes.
I was surprised. I'd been reading about the media, about the social media chatter, and knew that there was strong public opinion for him. But look at O.J. Simpson. There was strong public opinion for conviction, and look what happened. Jurors.
Casey Anthony, she killed her daughter and buried her in the back, and that's what a good lawyer does. People never open your mouth and send even an email when it could be compromised without talking to your lawyer.
Yeah.
I have a question.
Yeah.
And I don't know, we were talking about the relationship between the lawyers, and I noticed that when this trial started, she was just with one lawyer. She was sitting with one lawyer, and Johnny Depp was always with two. And then after the weeks, I don't remember, was the two or the last week, she starts sitting between two lawyers. There's something there, or that it has a meaning.
It could just be the way the courtroom's set up. I think they probably wanted her sitting next to one female lawyer. Mm-hmm. For perception, and then maybe it just became cumbersome, and so they put the other lawyer up there. The courtrooms this is actually a pretty good sized state courtroom. A California courtroom would be like half the size. I say state because there's two court systems in every state. There's federal and state court, and the federal courtrooms are usually twice as big as the state courtrooms. I've been in state courtrooms that were literally the size of a living room, and you've got an entire you've got jurors, you've got court staff, you've got judges, you've got lawyers, and this is a team. So it's not just the lawyers that are in the front are sitting up front. It's the lawyers sitting up front with the party. Then you've got the lawyers and the behind them, the paralegal, the trial tech person who's running the slides and playing the audio and playing the video. Then the first row of each bench is probably taken up with lawyers and paralegals, and then you have the people working in the office. So it's it usually gets pretty tight in there. But this courtroom seemed to be pretty big. But to get back to your question, I don't think it was for perception. I think it was more probably for some sort of practical reason. But originally, I think the one lawyer was for perception, because it doesn't make sense not to have Benjamin sitting on the other side unless he wanted more space, which is possible.
Okay, thank you.
Jesse, I know you have a 1 o'clock call, so we have 33 minutes. So we're gonna try to run. I will not gonna make any more questions because I do know you have another call at 1, no?
Yeah, so this is, and then we just have one more clip, and this is going back in time a little bit.
Okay, I want to be respectful. The reason we go longer is because I think this is awesome.
Oh yes.
We can cut this last clip too if you want.
No.
No, everything needs to go.
Yeah.
Heard accuses him of.
Just one more.
Okay, I'm gonna edit again. Okay, we're going.
Heard accuses him of. We ask you, we implore you
Oh,
to render a verdict
Again?
for Depp.
Susan, get your things together. Okay, I think I have this one.
Company infinitum. Stage photographs. That's what she documented. Mr. Rottenborn's entire argument assumes that Mr. Depp, a man, should be disbelieved because despite the fact that Ms. Heard can't support her accusations with actual evidence. What we have put to you, the jury, is not that because Ms. Heard didn't take enough pictures or tell people about abuse that it didn't happen. What we have put to you is that given how brutal and constant the abuse Ms. Heard claims, she would have had serious injuries. That's a fact. She would have had serious injuries that would have been observable in the pictures we looked at and by the witnesses we heard from, and would have required medical attention. That's it. Ms. Heard testifies to injuries that multiple people didn't see. What you have in the end is Ms. Heard's word. Do you trust it? We are not here.
Counselor?
Yeah, so this is a great theme. Do you trust it? Really that's what their case hung on, right? And the way that the Camila Vasquez frames it, which is there's an absence of evidence, and that's a continuing argument that they make. There's an absence of evidence. There's an absence of evidence. And Amber Heard's team fell right into it, right? They say, oh, well, we have video and we have audio and we have text and we have this and we have that. But they're missing, right, what we all would expect of serious abuse, which is a medical record. And I know Greta Hoff said in some interviews that the medical evidence was kept out. I'm guessing it was kept out because it was probably some sort of it was too distant in time, maybe, to have been relevant to actually addressing the alleged abuse. I don't know why it was kept out, but it is something that we were expecting, and we expect, undeniable photos. We expect the video, and maybe that's why the jury disregarded the video, because it's like, oh, well, this is just this is the only evidence that they could give us in years of quote unquote alleged abuse. And he's not hitting her. He's not beating her. He is being what I would consider to be abusive in that, verbally abusive, but he's not sexually or physically abusing her. And so they talk about that absence of evidence, and then they lay it up. Well, all you've got is Amber Heard, and do you trust it? And it's a very good, clean theme for the rebuttal and for basically summing up what they have, which is what and it's not true that that's all they have is Amber Heard's word. They have clearly other evidence, but they backed her narrative so completely that that's what they are, that is what they're left with. And it's not necessarily that the jury doesn't trust Amber Heard's word, it's that they don't trust her narrative. And that was the problem.
It's not the story, it's how she says the story and how she was overselling the story and under-delivered by the lawyers when they need to back up. She went so big expectations when they need to deliver something to back up the expectations she put out there. None of them were like, I donated. No, you played it. He abused me. Like, no, he never pushed you. And another thing, the thing is we're on, everybody have a dictionary. You're on the West Coast, Jesse. I am on the East Coast of Central. Elba is in Central America. We have different dictionaries, even though we speak English. So when we says physical abuse, we go to our memory dictionary. Like, okay, abuse for me is everybody who yell or elevate the voice to me, I consider abuse. So the image with Johnny Depp banging the cabinet is abuse. I have people who says like, that is not abuse. He wasn't taking it on her. He was taking it on the cabinet. I grow up with my dad doing that BS every day. So for me, it's not abuse. It's just banging the cabinet, but he never hit me. So because he never hit me, he never abused me. So not getting the narrative to what is abuse and make sure that every juror can understand and reach to their own emotional dictionary to make sure that they lead and get the verdict they expecting, I think was a huge mistake. Get the behavioral, people. What do you think, Jesse?
Yeah, I agree. I absolutely agree. I think that I think the fact that they were able to reposition what our expectation of abuse is or what our definition of abuse is was one of the most amazing parts of this trial, because abuse has really swung at least many people's definition of abuse, and I'm talking, not just I'm talking nationwide, and I think it has swung. But this trial shows it's not insurmountable. You can frame abuse as being only physical abuse, which I think is what the jury had to decide was abuse in order to come to their decision. And it's quite, look,
it's risky to let the jury to decide what is a term. Basically, this is about abuse. Oh, in the beginning it was abuse. Actually, they turned on that, but actually it was like, she's lying or not. People confuse what is this trial about it. But leaving the jurors to consideration something that is the core, the spine, the heart of this trial, it was suicidal.
Yes, it was. And it was a huge flaw in Amber Heard's case. Massive. Yeah, it really was.
We're going to do the closing from here, but I want to 5 top, 5 downs. You can talk about the makeup, the clothing, the lawyers. It's your show, Jesse. So the 5, that was my popcorn and happy moment, and 5, I wish I never saw it.
Okay, so 5 up. Well, Camille Vasquez's dress was amazing. I thought it was great. It was very well done counter to the long sleeved sort of dark clothing of Amber Heard. I thought Ben Chu's Me Too without a Me Too was a good theme. I don't know if it was delivered the way that I would have delivered it, but I thought it was good. I thought that, for all the faults on the Amber Heard team, I thought that their delivery was more raw and unscripted. And I think that it could have had power if it had the right content. I think that they are good trial lawyers. And I think that they could have they could have done better had they structured the case differently. I think that their problem was in visualizing and conceptualizing and framing the theory of the case and the themes. It wasn't their quote unquote presentation, although that had some problems too. But they're good lawyers, even though they lost this case. Let me put it that way. And getting back to Johnny Depp's overall case, they just did a really good job of making this, do you believe Johnny or do you believe Amber? And it was a hard sell. I mean, really, it was a very hard sell for lawyers to get through all of the defamation law and to get through all the video and all the text messages and to boil it down to him, you like him or do you like her more? And, framing it within that popularity contest, was a magical feat, and they were able to do it. The bad, let's see. Well,
we have so many. We have so many.
Don't run out of time. I mean, look, I understand when you go off script like Heard's team did, you gain some advantages, you gain connection, you gain flexibility, you gain, being present with the jurors, having them feel part of the moment, which is what you're supposed to do in trial advocacy, but you can't run out of time. And they did. And leaving only 6 minutes for rebuttal was problematic. Bretterhoff had to move very quickly because because Rottenborn took up too much time, and her speed and lack of any script at all. It appears that she had no script. It looks like she was just working off notes, which is too far on the other direction. There has to be some middle ground between scripting and being loose with how you present. She was way on the other end. She was unfocused, and I understand why she was moving quickly, and I get that. And people have to do that sometimes when they're running out of time. I mean, I once finished a 5-week trial with 9 minutes left on the trial clock. That's not for closing. That's for the whole case was only allowed to have 30 hours. And we finished in 29 hours and 51 minutes. And so I get it, but at the same time, you're supposed to budget for that. And even if your practice is to not script, you need to script in order to stay within the time frame. And in the end, what you say in closing is sometimes less important than how you say it. And moving quickly like that, the jurors they're not following. It's too sporadic and too all over the place. Look, going straight to the jury instruction, straight to the law as the start of your closing, that is not good. Look, the jurors are going to follow the law most times. I don't think they did in this case, but they tend to follow the law. Most jurors do. They don't have to be banged over the head with it. Just tell them why you should win and why you should, and why the other side shouldn't. That's how you start your case. That's how you start the very, very beginning of your closings. And finally, don't make the jury the bad people. Don't tell them they're going to suddenly destroy the Me Too movement if they find for the other side, or that they're part of the psychological abuse that's been perpetrated, if they find for the other side. That's not good. Look, there's a theory in trial advocacy called the reptile, where the theory goes like this: we have a reptilian brain that strikes out if we think that we are about to be in some way, shape, or form put in danger. And so, trial lawyers will do that sometimes. They'll say, look, if you find for them, then you're the next person. You're the next person who's going to be run over by a truck. You're going to be the next person. And then you're not going to get what you need to survive. And then the jury, the idea is to get the jury to strike out at the other side. If they were trying to use the reptile theory in this case, I don't think they were, but if they were, they did it in a terrible way. And it was way too broad for that. It needed to be more focused on particular instances of abuse. And so I think that theme of Brederhoff calls it psychological torture, Rottenborn calls it an accomplice, was not good. And I think that their client got punished for that. I really do. And then finally, look, jurors are going to see people. They're going to see who you really are. And if you think that you can escape 12 people, you can't.
No.
You can't, no matter how good of an actor you are, you can't escape 12 people. So own it. Own the flaws, own the problems. We've all been through it. Like I said, the hero journey is a 5,000-year-old story arc. We all understand it. We've all embraced it. We're people, jurors are people too. That you have to be able to own up to it, even if it means going on the stand and saying that you lie. You have to do it.
Gessin, one of the things that I love about your website and you is where the science of persuasion meets the art of advocacy. You're one of the few lawyers that I know and that we know that understand the behavioral, the trial, and how it need to get done, and how to explain things on the lame people to everybody to understand. It's been a delightful pleasure to share these 2 hours with you.
Yes.
Thank you so much for having me. Thank you. I'm much appreciated.
So we're going to close the show here. Everybody, you want to know more about Gessin and all the amazing things, we're going to put all the bio, and it's got a lot. So you're going to need to read all the way bottom so you don't miss any part. You're going to have his website, his email. He is amazing. And as you can see, that's the way Gessin is on the phone too. Thank you very much for being with us. Elba, my love, see you next week.
See you next week.
Bye, everyone.
Bye, everybody.